In the Bryan Kohberger case, with all the secrecy, the redacted documents, the non-dissemination gag order, we've penetrated through all that and actually found some magic in the Idaho 4 case.
The Kohberger defense is focusing in on one question. I'm Lainey Law.
And I'm attorney Andrew Myers.
So, Andrew, what is this about a magic question?
First of all, you're going to pull a rabbit out of your hat there, Lainey?
Listen, Andrew, I got no tricks up my hat except, what's this?
A rabbit. Magic. What happened to my magic wand? Boom.
So we have some magic happening in the Kohberger case today, but what could magic have to do with the legal process?
Well, we apologize in advance if we take things lightly sometimes because the case we know is very, very, very serious. But going through the documents this week, as I am prone to do, the documents are on the Idaho website, and you go through them, and you read this, and you read that, and I get to this document here. It says, and everything has to be sealed. We peons that pay taxes to build and support the courts, we're not allowed to see anything. Look at this. An order sealing defendant's motion to adopt voir dire procedure. The court having before it defendant's motion to adopt voir dire procedure and objection to magic question.
Magic question?
And so, we read down through this for good cause, appearing hereby orders that the motion be immediately sealed. Not sealed, but immediately sealed. You people out there in the public, you can't know about this. To preserve the party's right to a fair trial, the interests in privacy predominate over public disclosure, and sealing is the least restrictive way to protect the privacy interests at issue. Okay. All right. Well, so I saw this and I'm saying to myself, all right, I know about voir dire. I've done some trial work, a fair amount of trial work actually earlier in my career. And I'm saying to myself, the magic question, yeah, okay, all right, but I bet 90% of the people in our audience are not really totally familiar with the process. And as we all know, the voir dire procedure is how we select a jury. In other words, you bring in a veneer, you bring in all of the potential jurors. You might bring in 25 of them or 50 at a time, and you ask them questions. All right, what are those questions? And a little bit of background. 30 years ago when I started practicing law, this was just pretty much done on index cards. They gave you an index card and this person's a policeman. This person works for an insurance company. This person, does whatever. They're a student in school. And you look at those and you're allowed 3 preemptory strikes. You're allowed to just say, well, look, this is a personal injury case. And I don't want somebody that works in an insurance company on my jury. All right. Or if it's a criminal defense, the person is a police officer or is married to somebody in law enforcement, the defense attorney says no. So that's what peremptory strikes are all about. And you get 3 or 4, depending on what court, what jurisdiction you're in. So you get rid of those. But, a number of years ago, people said that's not enough because you really don't know these jurors. You don't know this room full of strangers. 25 people are in front of you in the courtroom, and you don't know who they are. So, some obvious questions are, you read the names of the witnesses. Lainey Law is going to be a witness. Oh yeah, I know her in school. She's my friend. Well, you're not even considered. Or if, as happened one time, I was trying a case in New Bedford actually, and one of the jurors said, yeah, his firm represented me.
Oh my God.
Anyhow, so the American Bar Association actually came up with some guidelines on how to voir dire a jury. And lest the people that always say, well, here Ann Taylor goes again, she's just trying to delay things. Just think if somebody got on the jury and they turned out to be biased, they totally believe in law enforcement or they totally hate law enforcement. So you're allowed to ask certain questions. And this is from the American Bar This is from the American Bar Association, and there are 11 guidelines, and the top 4 are really the most important. And this is advice to attorneys that are about to impanel a jury, which is going to happen in the Kohberger case as it's scheduled now, August 11th of 2025. So the American Bar Association is saying, here's what you do. Adopt proper orientation. Approach your voir dire questioning as a conversation, not a job interview. And the reason for that is you want to make the jurors comfortable, let down their guard. If you're just like, this is what we're going to do, and this is what the case is all about. Now, don't you kind of like, close down and not want to listen?
Yeah, I mean, I don't think anybody wants to. Well, I don't think anybody feels comfortable when they feel like they're presented with authority. I think if you come from more of the same level.
So orient the jury. Number 2, set the stage. Explain the process, stressing honesty and candor, and helping jurors acknowledge the filters and biases that we all have. 3, get them talking. Successful voir dire requires that jurors talk and not just listen to the attorneys, talk at them, using techniques such as the initial background summary, where all the jurors answer 3 to 5 basic background questions. So, you want to talk to them. You want to talk to the jurors. And I've seen some good attorneys that have done this a million times show you how you just set the jury at ease. And what do you think about a situation where you're in a college community and something horrible happens to 4 people? Would you make up your mind immediately out of fear? Things like that, just to set the stage in a formal but less, abusive kind of a way. And this is a really important one that we're going to get into a little bit more. Ask open-ended questions. Open-ended questions. For example, why? Why would you feel that way? Or what are your views on? What are your views on, the use of drugs on a campus? What are your views on people that party all the time? Provide more information than the closed-ended questions. For example, agree, disagree, yes, no. And the thrust of all of this is to, really get the jury to, be at ease so that you can then ask them really good questions. Here's what a court of appeals in West Virginia said. Once a prospective juror has made a clear statement during voir dire reflecting or indicating the presence of a disqualifying prejudice or bias, the prospective juror is disqualified as a matter of law and cannot be rehabilitated by subsequent questioning, later retractions, or promises to be fair. And see, our little character there in the bottom left is kicking them off the jury. And this is from the United States Supreme Court way back in 1985. The U.S. Supreme Court said, determination of juror bias cannot be reduced to question and answer sessions, which obtain results in the manner of a catechism. In other words, you don't just say, hey, can you be fair? Of course they're going to say, yeah,
I'm always fair. I'm the most fair person I know.
Or if you're one of those people that really doesn't want to do jury duty, you say, no, I can't be fair. I can just look at the guy and tell. So this is what the Supreme Court said. Don't preach. Don't give them a catechism because they're going to want to please you.
It reminds me, I might have told this story prior on the podcast. I have a relative that was called for jury duty, and they were upset because they went into the interview and they were trying to be as judgmental as possible.
Right.
And they still got selected. It's like they saw right through him. He's just like, he's trying too hard. I know he doesn't care.
That's crazy. We should interview him sometime. Then the next rabbit in the hat of magic questions, which Ann Taylor wants to keep out. This is from the Georgia Court of Appeals back in 2004. It is absurd and unconstitutional for a court to cut off inquiry and rely on an affirmative answer to a rehabilitative question from the bench as a talisman, something very important, to show that the jury has magically suddenly become unbiased and impartial. So there's our judge pulling a rabbit out of his hat. Yep. So what is a magic question, you ask? Well, here's one from a 2002 case in Georgia. This is an actual magic question that the appeals court had to bandy about. After you hear the evidence and my instructions on the law and considering the oath you have taken as jurors, can you set aside your preconceptions and decide this case based solely on the evidence and the law? Well, now, if that were asked in voir dire, wouldn't you just say yes?
Mm-hmm.
The judge is there, the lawyers are there, and you're down here, and they're saying, can you still be fair? So of course everybody's going to say yes, or your friend is going to say, no, I can't. So
I've never been fair or unbiased in my life.
So this is the kind of question that out of rote, out of habit, out of we've always done it this way, out of the form books. This is the kind of question that used to be asked. And, with expanded voir dire and problems with jurors, the courts are now saying, no, you don't want to ask these questions because there's no magic in the magic questions. And there's the rabbit saying, oh my gosh, you're going to pull me out of a hat. A record laden with leading questions by the trial court can leave a reviewing court uncertain about the sincerity of the prospective jurors' answers. The answers to such questions may suggest overt acquiescence in the trial court's effort to elicit a commitment to neutrality, but bias remains if the prospective juror tells the court only what it wants to hear, while covertly holding on to the previously articulated views that precipitated the challenge. And this is something that people have talked about in paneling a jury in a big case like the Idaho 4 case. People have said, well, won't people try and get on the jury, because they can write a book or they can do interviews? I mean, remember the Murdoch case? Within days after that case was over, 3 of the jurors were in New York on Good Morning America.
It was crazy.
Sadly, Rebecca Hill wrote a book which was largely plagiarized and has caused all kinds of other problems we talked about before. But so what the court is saying here is, don't ask these rote, simple questions that are like, it's almost like you're talking to a little kid. Don't you want to be a good boy and get presents for Christmas?
Don't you want to be a juror and watch history?
Exactly. So, these are seen as questions that are not great. And that's what a magic question is. Maybe it's a misnomer, but they call it a magic question. What is the definition of a magic question, you ask? A magic question, that is, whether the juror could set aside his or her allegedly biased opinion and render an impartial verdict based upon the law and the evidence. That's the definition of a magic juror. And the California Appellate Court has put a magic question as this. They didn't like it, but the standard for review in an appeals court is whether the court abused its discretion. But this question did get a lot of scrutiny, and I think California attorneys will not use it in the future. Is there anything you haven't told us that you think is important as to why you should not serve as a juror on this case? And isn't a juror, I mean, did you steal the candy out of the candy jar? No, they're all going to say, of course.
Yeah, that kind of just goes back to almost like bringing it back to an interview. It's just like, no, I haven't done anything bad. There's nothing wrong with me. I'm perfect.
Yeah, exactly. I mean, if you want to get on the jury and you're lucky enough to get on the jury pool and you say, oh, bada bing, bada boom, I know somebody that can ghostwrite a book for me. Yes, I want to. They're not going to tell them that. So the moral of the story, going back to the initial slide, the American Bar Association is saying, we want you to set the jury at ease. We want you to talk to them, not at them. We want you to think. We want you to get them talking. If something horrible like a quadruple M happened in your neighborhood, how would that make you feel? Would you understand that even though you had a lot of emotions about that, could you still be fair? How would you feel about the fact that law enforcement, more specific questions is the moral of the story. So bringing it back to our current case, Ann Taylor is saying, we want to avoid the problems that these other cases we talked about in Georgia and Colorado and U.S. Supreme Court. These questions that are just really blunt kind of, are you still beating your wife?
Yeah.
Questions like that, they're not appropriate. And they've caused appeals before. And even though the courts have gone both ways and the review is at the discretion of the judge, why create appellate issues? And it gets back to, I know there are people out there, the court's just delaying. Ann Taylor is just delaying. No, she's trying to make certain that there's an open, free, fair trial with all of the defendants' Sixth Amendment and 14th Amendment and Fifth Amendment rights all observed. And because if they're not, There's going to be an appeal. There'll be an appeal anyhow.
Yeah.
There's going to be an appeal, and there'll be another trial, and that'll delay things, who knows how long. So, it's a fair question that she asked. When I saw this motion, I said to myself, let me get it up on the screen better. I said to myself, come on, why can't we see that?
Mm-hmm.
Why can't we see? Now, maybe there's stuff in there that reveals, the true facts that have been hidden in, multiple discovery requests and 4 motions to compel, none of which have been acted on. So maybe I'm wrong. I've been wrong before, not often. But so maybe there's stuff in there we shouldn't see. But it would seem to me this is a legal argument that would be based not on necessarily the cases that I just talked about, but on those principles. It would seem to me that this would be a legal argument that people should be allowed to see, because this whole case has been veiled in tunnels and frat boys and Fortran and, all of that stuff. And it would seem to me that if the court wanted to, create a fair, unbiased jury pool out there, they might start unsealing some of this.
Mm-hmm. Yeah, I think that's going to be an issue that a lot of people have. And I think also it's going to cause a lot of interest in people maybe trying to circumvent magic questions and people wanting to be on the jury pool and stuff like that, is that everything is so under wraps. And I feel like if it wasn't such a hush-hush case, people wouldn't have nearly the level of interest that they have in this. So I feel like as someone that's being called for jury duty, knowing that you're kind of going to get access to like what's a big secret, I feel like that's going to entice some people to not necessarily be sincere or unbiased.
So as long as we're talking about unsealing and ungagging and undisseminating, is that a word, undisseminating things? The Boise, Idaho District Court has also very recently posted a message that here is how you can apply for some of the secreted, non-disseminated, redacted materials. And the court said, here's the procedure, here's a form, and here's where to submit the form. So I thought about it a lot, and I did it. I thought about what documents, and there were more than one, that I wanted to see and that I thought would be a great thing. And they said, well, why do you want to see them? And I thought, well, if I just tell them I'm just a run-of-the-mill podcaster, they're going to just say, which they might anyhow. And I fully expect them to go, But I said, I'm an attorney that's been practicing law for 30 years. I'm a member of the bar in 2 jurisdictions. I would like to analyze them and present them. I was honest. I said, present them on my podcast in a cool, calm, dispassionate, objective way through analysis. So they probably have a rubber stamp that goes, But I applied. I didn't want to be sitting here, a week from now, a month from now, a year from now, and say, oh, geez, I woulda, coulda, shoulda.
Mm-hmm.
So I've applied. We'll keep you in touch. I'll show you what the response is.
We do try to present all the documents that we can in unbiased manner. So, there's a lot of interest generated around this case that we would like to help educate people as much as possible.
Do we have time for one more Idaho update?
Let's take a look.
Okay. Okay. Idaho is at it again. Do you remember Thomas Eugene Creech? Thomas Eugene Creech is on death row, and a warrant has been issued. A D warrant. There it is, just issued, and here it is. They tried before. I don't know if you remember, we've talked about this on this podcast, but here it is, a second and new D warrant. The above named defendant, Thomas Eugene Creech, on the 28th day of August, 1981, pled guilty to the crime of first-degree M. That's not the whole story, but I'm just reading you the document. Whereas on the 17th day of April, 1995, the Honorable Robert G. Newhouse entered his findings of the court in considering the DP and a judgment of conviction finding that the above-named defendant, Thomas Eugene Creech, is guilty of first-degree M and imposing the sentence of D. And it goes on and on and it talks about the appeal, went all the way to the United States Supreme Court in 1999. And it goes on and on with the history. And they kind of gloss over a little thing here. Look at this. Whereas the execution of Thomas Eugene Creech could not be carried out by the Idaho Department of Correction and Idaho Code 9. They kind of gloss over the fact that back in February of 2024, Idaho tried to execute Mr. Creech. And we, as I said, we talked about this on a previous episode. Back in February of 2024, Mr. Creech was taken into the chamber and laid down and, strapped down to the table. And they tried 8 times to inject the lethal dose to him. They tried 8 times. They couldn't find a vein. So, it made me.
Yeah, it makes my skin crawl as someone that is very hard to get blood and anything. I can't imagine what that's like, especially waiting for death. Isn't it like acts of God or something at that point? It's just like
ridiculous. Yeah. I mean,
they tried so hard.
I take the needle when I go to the doctors and I've got to have an injection or a shot or a, whatever. I look the other way and I talk to the woman, try to talk to the woman about something else. Boy, those Red Sox did really horrible this year, didn't they? Yeah. Well, so are the Patriots. Oh, so by then she's done, but I don't like it. But to have, the guy is a convicted M, and those of you that are still in favor of the death penalty, yeah, he deserves it. But under the 8th Amendment of the Constitution, isn't that cruel and unusual punishment to stick a needle in a guy 8 times, and then after they couldn't find a vein, they send him back to the cell, and he's been sitting there since February. Well, the story behind the story, and he's like 73, 74 years old now. And the story behind the story is that Idaho apparently, based on that, when you just have a needle at the doctor, they just stick it in, and the first vein that it hits, you're fine. Now they have a deep injection system that they've installed in their chamber so that it hits a major vein, whether it's the jugular vein or another vein somewhere in your body. So they've changed the process. And don't forget, after the Kohberger case started, the Idaho legislature instituted the firing squad. Now, that's not what is in store for Mr. Creech, but nonetheless, so I just thought that was an interesting little story in Idaho. They kind of glossed over the facts, but, in this affidavit, they really didn't have to get into all of that. But poor Mr. Crump. I'm not going to say poor Mr. Creech because he admitted to one of the M's that he committed in a really truncated, expedited appeal. And he is scheduled. This is a command to the head of the prison system that you shall, on the 13th day of November 2024, you shall cause the execution of said sentence of death to take place unless said sentence is stayed by law, and that you shall make a return upon this warrant, et cetera, et cetera, et cetera, et cetera, et cetera. So, the date is November 13th. There's a truncated appeal process. They're allowed to take it. The United States Supreme Court has already denied certiorari, which means they're not looking at this case. So there will be, each side is going to be allowed to file briefs pretty quickly because the hearing is in early November. I can't remember whether it's on the 6th or the 7th, but then the date of execution is in mid-November. So Idaho is at it again.
It makes my skin crawl. It's hard, obviously, because, in a situation like this, is there really a right or wrong way to handle, someone who's been admitted to be guilty of but it just it makes my skin crawl. It feels so horrible. Obviously that person did terrible things, but at the same time, I think most well-intentioned humans, just knowing that they tried it and it went so poorly and now they're going to try it again, and then what's going to happen if it goes wrong, and how expensive is this, and
and also remember the guy's 73, 74 years old, which to me right now, that doesn't look so old. But on the other hand, he's no longer a kid. He's no longer even middle-aged, even arguably. So,
he's been in prison so long.
Yeah. So, there are a lot of questions that are much deeper than our very brief podcast today can get into. And I acknowledge all of those, and let us know down below. But I just thought that was an interesting little aside in that Bryan Kohberger is on deck for that if he's found guilty, although there are 13 motions that were filed by the defense attorney. Jay Logston signed off on them. And then the state, through the Attorney General's office in Idaho, filed 14 motions opposing the defense's motion. So the DP is very much on the table in the Kohberger case. It's going to be argued on November 7th in the Boise, Idaho District Court. I don't know what else to say. So I guess, that's my closing thought is that Idaho, you're good at making potatoes, but I don't know.
All right, well, now what are those potatoes being made out of? Oh, there's no magic in the justice system. There's no universally right or wrong answers.
There's no magic wand.
No magic wand.
No magic wand.
No magic, no tunnels, no rabbits. It's all just feels very bad. And obviously, as much as we enjoy making videos for you guys, it sucks that we have to be here. As the judge said, I wish I could say that I was happy to be here, but I'm not. Or whatever.
Well, we did civil law, and on a good day, we got 500 viewers. So, Anyhow, thank you very much for joining us today. Please subscribe and share with your family, your friends, your enemies. And again, thank you for joining us. Give us ideas down in the comment section. We do read them all. We've done 2 episodes recently, just reading your comments, and we get some good ideas, some bad ideas. We get some good ideas that we actually follow up with in other episodes. So thanks a lot. Have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.